Well, thanks everyone for joining us. This is a discussion about military commissions and Article 3 trials. I noticed that the description of the panel says military commissions versus Article 3 trials, but of course the policy is determined by this administration is not a either-or policy, but a both-and policy, so I think it's helpful to look at it from that perspective. I'm going to make some very brief introductory remarks, then going to introduce the panelists who themselves will make very, very brief introductory remarks. Then I'll ask some questions, and then we'll open it up to as many questions as possible from the audience. I am not a lawyer, and so I apologize in advance if I get any of the complicated legal concepts wrong, but I do know a fair bit about the politics of national security, and it does not surprise anyone in this room to know that the politics on this particular issue are incredibly dysfunctional and in many ways are hindering progress on policy. An analogy that was put to me recently was that it's similar to the politics of crime in California in the 1990s, where there was really no room politically to be smart. You just had to be tough. And if you weren't tough, you really couldn't participate in the conversation very well. The dynamics on this particular issue seem to me to be similar. No one really wants to accept risk, political risk or otherwise. The left and the right broadly, although there are many, many divisions within the left and the right, tend to talk past each other. The right's talk in many ways seems to tend towards intimidation. The left seems to be very defensive. The right often feeds off the left's intimidation, and the result is stasis in policy. And it's no surprise that the politics of this are difficult because it's a very difficult issue. How do we secure the population, oppose al-Qaeda, using the principles and values that make this country something worth securing and defending? So at this point, let me very briefly introduce our very distinguished panel. And you know, sometimes there are panels that you attend where the guests are sort of B-list panels, or Jimmy Fallon guests versus Jay Leno guests. This is not such a panel. These are A-level guests. To my immediate left is Stephen Shapiro, who is the legal director of ACLU. And to the extent that we collectively know a lot about, or anything about, enhanced interrogation techniques, renditions, the NSA's domestic surveillance program, a lot of that you can thank directly the FOIA lawsuits and the other work by Stephen and his 90 attorneys or so on this issue. To Stephen's left is Deborah Pearlstein, visiting associate professor, Georgetown University, the founding director of the Law and Security Program at Human Rights First, who has been to Guantanamo many times, who has essentially been working on this issue, this direct issue, since 2002, pretty much nonstop, and has written a number of very influential articles and position papers that I know have influenced members of Congress and members of this administration and angered members of the previous administration as well. To her left is Eugene Fidel, known to all of us in the media as the world's foremost expert on military law. He is a senior research scholar at Yale University, president of the National Institute for Military Justice. And then last but certainly not least to his left, Noel Francisco, the chairman of chair of the, I can't read my own writing, but I'll just
Government regulation.
The government regulation practice at Jones Day. More significantly for the purposes of this discussion, he was associate counsel in President George W. Bush's administration. He also was the deputy assistant attorney general in charge of the Office of Legal Counsel at the Department of Justice, replacing someone named John Yoo. So at this point, I'd like each of our panelists to spend a few minutes slicing and dicing this very large issue from their perspective and then we'll start with the questions, and we'll start with Mr. Shapiro.
Thank you very much, Mark. Since I guess I'm part of the representation of the left on this panel, I will try not to be defensive, but let me just say, why are they doing this to our Constitution? In the interest of fair disclosure at the beginning, I should explain for those in the room who may not know it, that the ACLU and the National Association of Criminal Defense Lawyers, NACDL, have jointly sponsored something we have called the John Adams Project to provide support for the defense effort for 5 so-called high-value detainees at Guantanamo, including Khalid Sheikh Mohammed, who were charged originally before military commissions and charged with capital offenses, so they were facing the death penalty. And we agreed to help support their defense because it was clear to us that the military commissions, as constituted at the time, and I would say as constituted now, were so grossly unfair in their basic composition, procedures, goals, and the disparity of resources that were available to the prosecution and the defense, that we had a role in both trying to fill the gap that the government itself was not filling, and through that process to expose the inadequacy of the military commission proceedings. So I'm not a disinterested observer. We have a stake in this fight. I think it is fair to say, or at least it's from my perspective, when we first started to think about this panel, I at least assumed that by now we would have had a decision from the administration about what it was going to do with these 5 high-value detainees who have become the symbol of the military commission process, although they are not the only people by far who are who have been brought before the military commission procedure. The Obama administration charged them and then withdrew the charges. As you all know, Attorney General Holder announced that they were going to be tried in criminal court. The administration seems to have since gotten cold feet because of pressure from among various other places, my hometown in New York City, and now they just seem to be incapable of deciding what they are going to do next, and I think there's a real likelihood that this stasis will continue until after the November elections. I think you really don't need to know much more. Well, let me put it this way. I think the argument that is sometimes made that military commissions are necessary in order to protect somehow our security, which would be jeopardized if these defendants, these detainees were tried in civil criminal trials, is a total red herring. I think the only statistic you need to know, and it's one that's been tossed around a lot, is that since 9/11 there have been over 400 successful prosecutions and convictions in federal court on terrorist offenses. There have been 3 convictions in military commissions, and the criminal process in Article III courts is well accepted, it's well understood, it's largely beyond at least facial challenge, whereas any proceeding that takes place in front of military commissions is going to be subject to years of challenge, and I think will be viewed as tainted in the eyes of most of the rest of the world, if for no other reason than it's a process that exists only for aliens under our law, which is to say it's a process that exists only for Muslims, and it's diluted due process. It's a system set up to get convictions, and I don't think it has credibility, and I don't think there is a necessity for it. Let me just say one other thing, and then I will stop. I know this is a panel about military commissions versus civilian criminal trials, but I do think that there are a series of important questions looming ahead of us that the federal courts and the Supreme Court ultimately are going to have to decide. One is the question of military versus civilian trials. A second is a question that the Supreme Court ducked this past year in the Kiemba case, the case involving the Uyghurs, and that is, what do we do with people who the courts have determined, and in the case of the Uyghurs, the government has conceded, do not belong in detention any longer, but we cannot find a place to send them, and we will not allow them into the United States because of our own politics. Must the federal courts order their release, or is there a separation of powers problem there? That's an enormously important question. Habeas doesn't mean very much if what you get is a declaration that you're entitled to get out of jail, but no order requiring the government to release you. Second, the D.C. Court of Appeals has just decided that detainees being held in Bagram at least in most circumstances, are not entitled to file habeas corpus proceedings. Everything we won in Guantanamo in terms of judicial review can be lost very quickly if detainees are simply placed in another prison, another detention facility somewhere else. This has never been about Guantanamo, and we don't solve the problem by moving Guantanamo. And third, and perhaps most importantly of all, the administration has now announced that after going through a sort of file-by-file review of the remaining detainees at Guantanamo, there are 48 detainees that it has identified who the administration claims it is unable to try and unwilling to release. And those people are therefore facing a perpetual life imprisonment without charge or trial. That is not a situation we have ever had in this country before. Presents obviously very, very serious issues that we are going to have to face sooner rather than later. And so I'll just stop there.
Thank you. Thanks to ACS and to Mark and Steve for having me on what is already a very interesting panel. Having been warned to keep my remarks brief, let me just say a few things, focus my remarks, I think, on federal courts. I do want to say at the outset, and particularly in response to Steve's opening remarks, that there is no question the title of this panel and this general issue implicates an enormous number of what I view as incredibly complex questions. Who can you detain? Under what circumstances? Are we in a war? If so, what are the boundaries of the war? What are the powers of the federal courts? And going back to, since the attacks of 9/11, unbelievably difficult questions, legally, politically, sociologically, technically, about how you can usefully elicit human intelligence from suspects who don't want to give it to you. The range of important issues here is enormous, and I think their complexity can easily be underestimated. I think it often and generally is in the political debate these days. Having said all that, I have thought, since I started talking about these issues, which now feels like, a million years ago, that the question of, once you have decided to prosecute somebody, what's the best forum for doing it? Or what are the useful forums? What is a useful forum for doing it in? Is really the easiest one, or close to the easiest question that we have faced. That is, this is not a question of should we, can we, do we have the authority to detain this person at all? That is not an issue. The issue is, we think they've done something bad, criminal, whether it's a domestic criminal offense, a war crime, and we want to prosecute them. How do we go about doing that? Because of all the questions that I just outlined at the beginning about interrogation and detention and the rest of them, the experience and the question of how do you try somebody and fairly and reasonably adjudicate their guilt or innocence is one that the United States, and indeed the rest of the world now, has an enormous amount of experience with, and we've actually given it a great deal of thought over centuries of time. Having sort of prefaced my remarks with that, it will, I hope, not surprise you to say, I think the vast majority of cases, and perhaps all of the cases that we're now struggling with, particularly including the so-called high-value detainees, some of whom are held, or who are now held at Guantanamo Bay, the appropriate forum for the trial of these individuals is the federal criminal courts. Now, I say with some exceptions, and I'm very happy to talk sort of in Q&A and as we have a conversation, what those might sort of theoretically or conceivably be. But why do I think the federal courts are such a sensible forum for terrorism trials? Let me make a very, very brief affirmative case, picking up a little bit where Steve left off, and then just highlight a couple of the reasons why, or the reasons I find even modestly persuasive why we think in some of the recent cases military commissions have been the way to go. So as Steve mentioned, the record sort of speaks for itself. In the time the military commissions have prosecuted 3 individuals since 2002, of whom have since been released, served essentially several months or no time at all. The federal courts have won unsealed convictions alone, 400 cases, looking between 2001 and 2010, a conviction rate of something like 90%. Does this mean that federal criminal prosecution is the answer to terrorism, which is often one of the arguments advanced for why we need a military structure, military commissions? No, of course not. And I actually don't know anybody who argues that the entire problem of terrorism and threat of terrorism is solvable by federal criminal trial. But what it does mean is that federal criminal prosecution, under certain circumstances, is an extraordinarily powerful weapon for securing the legitimate long-term detention of people who have engaged in or who are in the process of planning terrorist attacks on the United States. It is the only reliable font of institutional experience as compared to a military commission process, which I know Jean will talk about in more detail. And the existence of a body of case law of an experienced, now increasingly experienced bar of federal criminal prosecutors, defense lawyers, judges, trial staffs, and so forth who've dealt with these cases is no small matter. Along with, and I'll just give one anecdote because I was talking with a prosecutor in the Eastern District of New York who's now prosecuted several major terrorism trials, who was comparing military commissions to federal trials and who has had indeed some exposure now to both, who said, which was a novel argument to me, which is unusual in the last recent years where I've been doing this, that in fact the particular challenge of getting evidence overseas, he found, was easier to do through a federal criminal process than it was through the military commission process. Why? Well, the FBI and federal prosecutors now have a lot of experience dealing with foreign law enforcement agencies, other foreign sources when they need to use intelligence or information evidence to introduce in federal trials. The military commission process struggles with itself domestic interagency problems about getting information out of one agency or another for use in the military commission process, and also has a much greater burden to get, and some countries have simply refused to share evidence for use in the military commission trials because for various reasons, either its historical record or indeed concerns about contemporary procedures, won't share evidence with the United States for use in military commission trials because they don't think the system is fair or reasonable or otherwise appropriate. And the federal criminal justice system is, if not above criticism, of internationally unquestionable, or at least far less questionable legitimacy. Now, why does that matter? It matters for practical reasons like the one I just gave. It matters for one might call strategic reasons, that is, what are we trying to do in a long-term struggle against terrorism, including persuading people that we're not in a war with Islam, and in particular swaying what have been called wavering neutrals, that our side is the side of right and good and justice, to speak broadly. So for these reasons, it seems like federal criminal trials have a huge amount going for them. So what are the arguments? And I'll just name, I think, for present purposes and in the interest of brevity, 3. What are the arguments that we need to do something else? One of the arguments that's been perennial since 2003, and to my surprise, at some level continues to exist today, is the notion that military commissions are better designed procedurally to handle classified information that may be needed for the prosecution of various defendants than are the federal criminal courts. And this is a complex argument, and over the years, one can respond to it in various ways, but now with the revised, and I would say much improved, set of procedures applicable to the military commission trial since the enactment of the Second Military Commissions Act in late 2009, the procedures for the handling of classified information in military commission trials are now essentially identical to the procedures available for handling classified information in federal criminal trials. Indeed, the procedures for handling classified information in the revised military commissions were modeled on the federal law that handles classified information in federal court, and indeed has, I think, expressly adopted that body of jurisprudence in law and decisional law that's been available in the federal criminal courts throughout this period for dealing with the complexities of handling classified information. So it seems to me that at the very best, that issue is now a complete wash. The rules are essentially identical in both
Can we just go very quickly through the last two, because
Yeah.
I apologize.
The second
I'm
is
the mean moderator.
No, good. The second is the money issue, which has come up more recently. Federal criminal trials extraordinarily expensive. Recent stories, and depending on what numbers you believe, we've now spent on the order of $2 billion on detention and trial operations at Guantanamo Bay. In no other area does money seem to be an issue. So I'm skeptical of the money issue on why we can't do federal criminal trials for the high-value detainees. And finally, and maybe this is best left in the interest of time for Q&A, but I think, unfortunately, may be one of the most important issues, that somehow prosecution in federal trials, either because of the need to Mirandize suspects or for other reasons, prosecution at all, precludes interrogation of the useful gathering of human intelligence information. I think this is some combination of wrong and overstated, and I'm happy to explain why in detail, but this seems to be, of the three issues that I discussed, the one that has, at least currently, the legs that we might want to address our attention to in Q&A.
Mr. Fidel.
The words that come to mind for me now, when I think about military commissions, are just two. Stop digging. I began my involvement, engagement with these issues when President Bush, the younger, revived this institution shortly after 9/11. At the time, I think I was an agnostic. I thought it was fascinating to see a museum piece revived. I'm kind of a student of legal institutions. I have to say I'm no longer an agnostic. So let me make a few observations and anticipate that we'll get some fabulous questions that will permit the whole panel to engage. My overall observation is that in a democratic society, the highest good in cases of antisocial conduct is that there be public confidence in the administration of justice. Now, you could say that's not really the highest good. The highest good is really to punish, and it doesn't punish, deter, et cetera, and it doesn't matter whether there's public confidence in the administration of justice. In non-democratic societies, who cares? We happen to have a democratic society, so we say, and therefore public confidence, I believe, as an article of faith, has to be the yardstick against which we, at the highest level of generality, measure the effectiveness and utility and value of programs. So what affects public confidence in the administration of justice? One, outcomes that are objectively accurate. That would seem to be a pretty good starting place, and what that means, of course, is that that your system convicts and punishes those who are guilty, and that it does not convict or punish those who are not guilty. A second criterion would be that sentences in cases of guilt are within reason, and a third is that the proceedings would be conducted with reasonable dispatch. These are the highest level, highest order of generality. So in a word, how did the military commission stack up against those criteria? I would have to say that, basically the objectivity test has been met. I can't think of a case, there have been almost no completed prosecutions, and I can't think of one in which you could say that an innocent person has been convicted. Nor can I think of one in which a guilty person has been acquitted. In the few cases in which there have been sentences imposed, I can't say that the sentences have been unreasonable in either direction. There was some consternation, of course, when one detainee tried by military commission got the effective benefit of time served, and in fact was free a few months after conviction. But basically sentences on the very, very small database that we have for all these years of activity and hundreds of millions of dollars that have been expended in this area. You can't really fault them on that basis. And then finally, I identified that the proceedings should be conducted with reasonable dispatch, and personally I would award a grade of F- to this system, if there is such a grade. Even if you allow for the various stumbling blocks that have been created by the energetic and largely effective pattern of litigation involving the military commissions, the slow pace of the administration of justice in the military commissions is mind-boggling and indefensible. The impression I took away from just sitting in the hearing room in Guantanamo was that judges were indecisive, that it was enormously cumbersome to conduct trials in Guantanamo, and it was no wonder, in fact, that things were taking as long as they had been. And this, the stately pace has continued. I don't understand it, why now 2 administrations, if you assume the utility of this institution, have not been more effective at moving things forward. Now, let me descend a little bit from the 50,000 foot elevation and talk about more specific things that I think really cast doubt on whether this institution fosters public confidence in the administration of justice. My impression, and it's a strong impression, is that there is, for all the time and effort that has elapsed and been invested, amazing uncertainty as to the law. And I'm not talking about law professors' uncertainty. I'm talking about uncertainty on the part of the people who are litigating these cases at trial and on the part of the judges who are presiding at the military commissions. I did not have the feeling when I observed at Guantanamo that the person sitting on the bench had the kind of firm hand on the tiller that I expect from any federal judge. Is public confidence served when you have the key legislation, key parts of the key legislation basically being decided behind closed doors in secret negotiations, the course of which is never really revealed? This has happened with both of the Military Commissions Acts, and it's not the type of thing, I think, that contributes to public confidence in the administration of justice. The specific rules, something called the Manual for Military Commissions, issued first in 2007 and then again in 2010, were promulgated without notice and comment rulemaking, despite requests for notice and comment rulemaking.
On the day the first trial began, as I recall.
What's that?
On the day the first trial actually
The second
began.
one, yes, it
Right.
came out
Right.
the evening before
Right.
the first trial. Nobody in Guantanamo had a copy of the rule book. The rule book is the size of the, let's say, Montgomery County telephone directory. That in itself it runs in the opposite direction from achieving public confidence in the administration of justice. As anybody familiar with the development of federal rules, either court rules or agency rules, can tell you. Worse yet, when the 2010 manual came out, the world was left to guess as to, A, what had taken so long. A little bit of that has leaked out. But B, what the changes were from 2007 to 2010. The organization I had in my spare time, the National Institute of Military Justice, put together a team, said, don't do anything else, compare these two rule books. And we came out with a memorandum that is our best guess at what the changes were. Tell me why the Pentagon didn't issue the memorandum that you have to assume someone generated, explaining to the Secretary of Defense what the differences were between the 2010 volume and the one that preceded it. I'll just make 2 more brief points if I can. Have you heard about the Guantanamo 4? That's what I call them. 4 journalists, including Carol Rosenberg, who writes for the Miami paper, have been expelled basically from coverage of the military commissions because they had the effrontery to name a witness who testified in open court. The ground rules that the Pentagon issued for the military commission trials provide that interrogators should not be named publicly. In this case, the interrogator had himself previously been convicted by a court-martial for misconduct, and therefore his name was known, and in addition had given media interviews in his own name prior to the trial at which he testified. Frankly, I think it's preposterous that the Defense Department has expelled these people. By removing Carol Rosenberg, they've, in my opinion, decapitated the Fourth Estate in terms of regular coverage of the proceedings at Guantanamo. Maybe they'll be able to work something out and some face-saving gesture that will permit these people to go back. But talk about having a sword of Damocles over your head. This is completely antithetical to open courts and honoring the First Amendment, particularly where you have a courthouse that you can't get to without the active approval of the Department of Defense. You can't get there. So this is not like some minor problem at John Marshall Place downtown here. I hope that it's litigated, to be honest. I hope they don't make a deal because I'd like it to be litigated so we'll get some federal judge or judges to rule on it. Now I'm going to make my last point, and it's one that is kind of a disturbing, it's really a downer. You know, against my, I'm really, it's just sweetness and light, right? Here it is, and it's pretty grim. We've had now a pattern, the beginning, God forbid, of a pattern of terrorism-type charges against United States citizens. These cases are, in my opinion, difficult to distinguish in principle from the kinds of cases that the government has proposed to, or in some cases has, prosecuted in military commissions. The more involvement, the more times United States citizens who are not subject to the military commission process come under the suspicion, let's say, of terrorism-type conduct, the harder it becomes to justify having a separate system of military commissions. That's a grim thought, but I think you have to take account of it. Thank you.
Mr. Francisco, since you are the designated foil, you can take a few extra minutes if you so desire.
Well, you know, I'm convinced.
Or
Thank you very much for having me here today. Thank you very much to the American Constitution Society. It's always a pleasure to come and appear before this group. And in response to Mark and Stephen's opening comments, I have to say, I'm shocked. I'm shocked that you all think that politics has intruded into this process. Those were the bad old days. In the bad old days, we made national security decisions based on politics, not policy, based on a narrow ideology, not an examination of the merits of the issues. But we're in the post-partisan era now where we don't take those considerations into account. And so I'm not sure what this administration is going to conclude with regards to the use of military commissions, but I do very much look forward to seeing what the result of a purely non-political, purely non-ideological analysis of the issue will produce. And I very much welcome seeing what the result of that process will look like. That being said, regardless of the decision that President Obama and his White House counsel's office produces, I think that there is a very powerful case to be made for the use of military commissions. And, you know, we can have a debate over what mix there should be between military commissions on the one hand and federal civilian trials on the other. But if your starting point is that Khalid Sheikh Mohammed should be charged in a federal civilian trial as opposed to a military commission, you're essentially saying that there's no mix. Because if the mastermind of the September 11th attacks is somebody who is suited for a civilian trial rather than a military commission, then I think that what you are effectively saying is that we should not have military commissions at all. And I understand that is the position of some of our panelists. I don't know if it's the position of all of them. Putting that aside, to me, the real case for having a system of military commissions is one that really addresses a lot of the issues that Eugene raised in his very compelling and interesting remarks. He did a very nice job of explaining what I think is the beauty of our civilian criminal system of justice, the paradigm for the world. It's a system of justice that's predicated on the notion that we're better off letting many guilty people go free than we are convicting one innocent person. And you can fill in the number, 25, 100 guilty people go free, rather than convicting one innocent person, because we distrust the state, we distrust governmental power, and we put the government to an extraordinarily high burden before we allow them to strip an individual of their liberty and in some cases their life through the criminal process. That is our civilian criminal justice system, and it's, in my view, the envy of the world. I would submit, however, that that is not and should not be the view of our military wartime justice system, and I use the term justice as shorthand, but I don't really think it's a justice system at all, nor is it intended to be. Rather, the point of this military wartime justice system is to protect the civilian system from external threat, to prevent others from destroying the civilian system so that we can keep it in place for the vast majority of people in this country that it protects. That's why when it comes to civilian justice, we have and we tolerate no concept of collateral damage. But that most decidedly is not the case when it comes to wartime, where for better or for worse, we do acknowledge the inevitable consequence and sometimes even the need for collateral damage in order to pursue and accomplish wartime aims. And to me, the real benefit of having a system of military commissions in place is that it prevents the dangers to the vast majority of the people that are subjected to civilian justice that will necessarily arise when I think you start forcing into the civilian justice system individuals for whom civilian justice was never intended to govern. In other words, the real danger is that when you blur the line between a system of military justice and a system of civilian justice, I think inevitably one of two things is going to happen. On the one hand, what you may see is detainees captured on the battlefield and put into a civilian justice system, accorded the very same rights that we accord everyone else in the civilian justice system. Maybe you'll see that. For example, maybe we will see ourselves Mirandizing and according the full right to counsel, the right to a speedy trial, and everything else that we accord to civilians in the civilian justice system. We may accord those rights to individuals that are captured and detained on the battlefield. And I would submit that that would be detrimental to our national security, but that's not my main point here, because I doubt that that's what's going to happen. I think the much more likely outcome is that you're going to see civilian courts adjusting the rights that we ordinarily accord civilians in a civilian judicial system. You're going to see our courts bending those rights in order to make sure that they're taking into account the unique circumstances of detaining somebody on the battlefield and bringing them into the civilian court system. So, for example, how is our civilian court system going to handle the concept of Miranda and the right to counsel when somebody who is in the civilian court system was originally detained on the battlefield? Are we really going to accord them the same rights of Miranda or the same rights to counsel? Or are we going to see something like we have seen proposed, which is to create an exception to those rules, an exception to Miranda, to govern that class of individuals for whom Miranda is not well suited. And if we are going to allow the camel's nose under the tent, there is a large there's a large body of thought in this country that doesn't like Miranda at all. And if we're going to let the camel's nose under the tent for these detainees, are we going to be able to limit it there? Or is that camel's nose going to go further, and is it going to start intruding into civilians in the civilian justice system who are kind of like the terrorist? A gang member who is in an organized violent group that's sort of like a terrorist group. Maybe not quite like it, but sort of like it. And then where does the line stop from there? The confrontation clause, a well-established right in this country that in a civilian court, you've got a right to look your accuser in the eye and make him look you in the face and tell him that you did it. How are we going to adjust for that right when we're talking about somebody who was detained on a battlefield, whose witnesses were on a battlefield, whose witnesses may not actually even be U.S. soldiers, but Allied soldiers, maybe even the Northern Alliance in Afghanistan? How are we going to accord that right to confrontation? Maybe we will. Maybe we'll apply it just the same as we do in the civilian justice system. But maybe we won't. And I suspect we won't. Maybe we'll adjust that right to take into account the unique circumstances of somebody detained on a battlefield. And if we do that, are we going to be able to hold the line there? Or are we going to start using that, as we often do in a common law system, to analogize to similar circumstances? Similarly, not identically, but similarly situated individuals.
To
me,
go ahead.
I'll wrap it up real quick.
Yes.
To me, the benefit of keeping the two systems completely separate is that you don't allow that bleeding of one into another. You have a military commission system that's meant to govern types of people that are detained on the battlefield for whom civilian justice isn't well suited. Accord whatever rules of due process you want. We can debate about how much due process you should accord in that military commission system. But at least when you wall that system off from the civilian system, you minimize and to a large extent eliminate the danger of having the necessary deviation of rights in one system from bleeding into another. And that's, after all, similar to what we do with our soldiers, where we subject them to courts martial rather than civilian courts, and it's similar to what we have historically done with prisoners of war. That's all I've got.
Thank you.
Thanks.
I'm going to want responses to that. But the fact is that the system hasn't been walled off. This administration has made a decision to mesh them together. So at least until the end of this administration, the reality that we have to deal with is some hybrid situation. We can discuss ideals, but that also goes to the question I want to ask you to respond, Stephen, in the following manner. If you're the Attorney General, you're President Obama, you know what the situation is like in Congress, you know what Congress is likely to do if you push ahead with your preferred solution. So based on the political realities, become Commander-in-Chief and tell us right now how to untangle the system in the process of responding as well to Mr. Francisco.
Okay. Let me just begin by saying I appreciate Noel's comments, because I actually think we have found common ground, and the common ground is that the military commissions are not about providing justice. That is not their goal, and that's not what they're designed to do. And I think even as a matter of national security, that is counterproductive, because I think the rest of the world has understood that as well, and it is part of what has made Guantanamo a symbol and a recruitment device for terrorists around the country, rather than something that protects our national security. The other thing I would say is there may be a role for military justice as well as a role for criminal justice. But to say that there's a role for military justice is not to say that there is a role for military commissions. We have a system of military justice in this country, and I will let Gene talk about it because he is an expert on it and I am not. But I think there may have been a lot less pushback if first the Bush administration and then the Obama administration had relied on the Uniform Code of Military Justice in establishing trial procedures in Guantanamo, rather than trying to create a system from scratch, which is what they have attempted to do and failed miserably in doing in creating the military commissions. The third comment, and then I will wear my hat as Commander-in-Chief, but the third comment that I would say is I think it's a little misleading to use the battlefield metaphor and to say, what are we going to do when we capture people on the battlefield, and are we going to Mirandize them, and are we going to provide confrontation clause rights? Because if what we are talking about as the battlefield is Afghanistan and Iraq, the truth is relatively few people who are facing trials either in criminal court or before the military commissions have been captured on that kind of battlefield. And instead, I think what is often meant when people refer to the battlefield, and I don't want to put words in your mouth, Noel, is premised on the notion that we are fighting what the Bush administration called the global war on terror, and therefore anywhere terrorists exist anywhere in the world is by definition a battlefield, and any terrorist we capture on that battlefield can be treated as an enemy soldier. I don't accept that paradigm, and I think that the evidentiary issues that you are posing look a lot differently when we get outside fields of active combat and start treating the entire world as a battlefield. Now, in answer to your question, Mark, about what I would do if I were President Obama, what I would do if I were President Obama is to support my Attorney General. I think the Attorney General made the right decision originally, which was to try, in particular, the high-value detainees that I know the most about in federal criminal court. I think the administration left him out hanging a little bit, and that was unfortunate. I have no doubt that it is going to provoke a response by Congress, and Congress may even attempt, if they go through with this, to bar the appropriation of funds for federal criminal trials. Frankly, I think as a constitutional matter, Congress does not have the authority to do that. I don't think Congress can tell the executive where to prosecute somebody. I think that that is an executive function, and it raises very interesting separation of powers questions. And I think this is a matter not only of such fundamental constitutional principle, but in the end, I think constitutional principle and national security interests coalesce here, that I think the administration ought to make a stand and defend it.
We're going to open it up.
Could I?
Yeah, go ahead. Yeah.
If I could just respond to some of the comments, in particular, too, I think Noel raises at least two very important points. The first is, this is in no particular order, whoever could be tried in front of a military commission. And I think there are at least a couple of answers to that that I think don't map on to the decision-making the administration has so far, the Obama administration has so far pursued with respect to who they're going to prosecute in military commissions, recognizing that their decision-making is at least in part constrained, unfortunately constrained by the threat of Congress and what actions they might take. But who can be tried in front of a military commission? Well, under U.S. Supreme Court law and the law of war, it has to be incident to the conduct of war. There has to be an armed conflict recognized under international law as an armed conflict. Some of the people, one of the people in particular who's now a defendant in front of military commissions, is charged with engaging in activities, terrorist/criminal activities that were committed in 1996. What war was it that we were engaged in 1996? In particular, the authorization for the use of military force, on which so much of this turns, wasn't passed until 2001. So there, I think it's there's just a basic legal question I think we have to struggle with. The second requirement is that they be charged with offenses under the law of war. These are war crimes trials. There has to be a recognized international law offense under the laws of war that they're being tried with. I don't know any international law expert in academia or elsewhere who thinks that the material support offense that currently exists under the military commission statute is an offense that's recognized under the law of war. So you have to charge them, it has to be a war, you have to charge them with a war crime. Even if you meet those two criteria, still, under certain circumstances, the right result would be to prosecute them in front of courts martial. Why? Because the Geneva Conventions provide that under certain circumstances, including the ones I just described, the defendant is entitled to the same trial the same system of justice as the armed forces of the detaining power. In other words, if we're going to prosecute somebody else for a war crime, it has to be the same system of justice we prosecute our own soldiers for, under most circumstances that we'd be talking about these. So there are several criteria, and I could go on, but we're just not hitting the right buttons. The decision about military commissions versus federal criminal trials is being based on something else. Now, what it's not being based on, and this relates to the second point I want to make, what it is largely not being based on, and I think, again, Miranda may be sort of a singular exception to this, and we can talk more about that in a minute. What it's not being based on largely is some sort of procedural distinction about, for example, confrontation clause protections, or many of the other sort of protections that Noel was talking about how do we deal with this in a prosecutorial setting. Why? Because, as I noted before, from 2001 to 2009, the procedural rights available in the military commission trials, which started out here, as compared to the procedural rights available in a federal criminal court, have gone like this. They are not now identical. Hearsay remains a sort of relevant and important distinction, although one that I think would hold up in either federal criminal courts or military commissions. But the procedural rights available to defendants in both processes are now very close to the same. Again, a few exceptions, but that is not, I no longer believe or find compelling that is the singular most important reason why we would maintain this distinction. If it is, it raises the concern Steve maintains, which is, why is it okay to prosecute U.S. citizens in one court and okay under the Equal Protection Clause, among other things, to prosecute others in a different court. And the final point I want to make about this sort of bleed-over effect, that is, if you start trying terrorists in federal criminal court, you will pervert the civilian criminal justice system, the procedural rights and so forth, so much that it will end up as a diminishment of everyone's procedural rights in the criminal justice system. I guess I would say this. I don't see compelling evidence that that's happened in the last decade as these 400 trials have gone on. And we could have a conversation about what examples exist that would support that view, but I haven't seen that happening. And the second question is, it's not the second question is, who do we want making the decisions about where that's going to happen, where those lines are going to be drawn? If there needs to be exceptions to Miranda confrontation clause, many of which exist already in the federal criminal courts, who do we want doing that? My money is on the federal criminal court judges, who have been doing it for a lifetime, not only personally but institutionally, as opposed to the very able but not as experienced convening authorities and so forth who are now struggling with those issues in the military commission courts.
If I could, my response to Deborah and Stephen is similar, because I think we start out from a slightly different point. I do not believe that every single one of these cases that can arguably be labeled terrorism ought to be tried in a military commission. I think, as in many things in this area, there is a spectrum, and to me, the more that it looks like a foreign attack on the U.S. system, the more it is likely to fall into the military commission regime, the more it looks like an act of domestic crime, then it ought to fall in the civilian justice regime. That's why, Stephen, I actually do, in my own mind, and when I use the words battlefield, I am talking about a traditional battlefield where we do pick up somebody on foreign soil engaged in hostilities against the United States, like most of the detainees that are being held at Guantanamo Bay and in places throughout non-U.S. soil throughout the world where we are in battlefield conditions. And that, to me, is the paradigmatic case where we do need a system of military commissions, because putting those types of folks into the criminal justice system is precisely where you're going to have, in my view, the highest amount of pressure to bend the rules. I don't know what these 400 cases are. You all study these, I think, probably more closely than I do, but I suspect that we would probably agree that most of them don't fit what I think the paradigmatic case for the need for a military commission is. But when your starting point is that Khalid Sheikh Mohammed goes into the civilian justice system, you've completely rejected my approach, which is to recognize that there is a spectrum of cases here, at least some of which are appropriately tried in military commissions, because if Khalid Sheikh Mohammed doesn't get a military commission, then who does? Osama bin Laden? He's about the only other person that you could peg as worse than Khalid Sheikh Mohammed, and how much worse is he really? Is enough worse to justify that differential treatment? I think you're effectively saying no military commissions across the board.
All right, very, very briefly, then Jean, I'll give you some response, but you can respond very briefly, and then Jean, and then we'll open up to audience questions.
Sorry. So I guess two responses. One is I would just disagree with the characterization about the characterization that you seem to have, which is more impressionistic than legalistic. I would say about, if it looks like a war, you can try them here. If it doesn't look like a war.
I think that's how we make lots of decisions in this area. It's not impressionistic. It's to recognize that facts and circumstances are different and there's a spectrum.
There are, but there is actual law here, and more law than I have the sense that you're acknowledging about how that decision has to be made and how it's constrained. But the other point I want to make is one that I guess goes to the question of KSM in particular. And in addition to the point that, my fear is, my sense is, both politically and in our discussion here, that decision is being made more impressionistically than legalistically, and I think there are legal constraints here that we're selling short, is a separate issue, an additional issue. Just because you can do something under the law doesn't mean you should. And when I say should in this context, I mean should in the interest of U.S. national security, should in the interest of effective prosecution, should in the interest of justice. When we prosecuted Zacarias Moussaoui, who you might also put in that category, I don't know, or the first World Trade Center bombers, who you might also put in that category, or some of the other coal bombers, who you might also put in that category, for whatever criticisms you might raise of those criminal prosecutions, those defendants have now been convicted and are sitting in jail for the rest of their lives, and nobody thinks another thought about them. Those cases are over, and generally, broadly, the view is that justice has been done. 9 years later, KSM, who broadly everybody thinks is one of the people singularly most responsible for the worst terrorist attack in U.S. history, has not yet faced criminal justice, any justice. And to me, that record for the United States under any of the should metrics that I outlined, national security, effectiveness, fairness, is unconscionable.
Jean.
Right. First of all, Mark, I'll hassle you a little bit on your introduction. You referred to the fact that we have a hybrid system at the moment. I don't think we have a hybrid system. We have a range of options.
The administration has chosen both and.
Right. I think that's different
from
having a hybrid system. But anyway, and if I can echo what Deborah just said, I mean, the fact that we can do something doesn't mean that we should do it. And I think we should not conflate those two steps in the decisional process. My personal take has evolved so that my view is, and has been for a few years, any case that can be prosecuted in federal court should be prosecuted in federal court, as opposed to a military commission. Now, I wanted to add a couple of other points, sort of footnotes. On the bleed over, that's a terrible term, and there's got to be a better word, but we know what you mean.
Let's call
spill over. Bleed over, not so much.
BP over.
We've all had a crash course in 18th and 17th century habeas corpus law over the last several years. And it does bring to mind the battle that the common law courts fought in England with the non-common law courts, one of which was the Court of Star Chamber, which had some unusual and unfriendly ways of extracting evidence from people. And I must say that I think it's worth bearing in mind that the English did not retain the Court of Star Chamber because they were concerned that if they got rid of it, Star Chamber approaches would then sort of wend their way into the administration of justice in the Court of King's Bench and the Court of Common Pleas. A little bit of history there. Another little bit of history is if you go back and examine the complete history of the current era of military commissions, you will find that the key document was not President Roosevelt's 1942 order. It was a law review article in a publication called the Oklahoma City University Law Review. I'm sure you all read it every month. There was an article in, I think, the late 80s. When was the Oklahoma City bombing? 95. Then it was way before that. No. That's fine. It would have been 95. And subsequent to the Oklahoma City bombing, there was a law review article that suggested, in light of the Oklahoma City bombing, hence the law review selected, the use of military commissions for prosecuting terrorism. In other words, this was not advanced with respect to foreign terrorists. That was an inside job. That was, domestic terrorism. So, I think that's a fact here that people have lost sight of, that the starting point. And how do we know, what's the connection between that law review article and where we are right now? Because former Attorney General Barr brought that to the attention of the Bush White House. That's the path, okay? So those dots do connect up. Now, the last thing I want to say is, the notion that somehow we have to have military commissions that are this sort of variant that has been discussed. You've got to tweak Miranda. You've got to worry about the confrontation issues and so forth. That's sort of inevitable with military commissions, or right to counsel, inevitable problem. I'm sorry to complicate this. It turns out that Congress, in its infinite wisdom, has created two flavors of military commissions. One is the one that was created for unlawful enemy combatants starting in 2006. That is Chapter 47 of 47A of Title 10 U.S.C. But they never repealed the provisions of Chapter 47, which is the UCMJ, that also authorizes military commissions. Okay? So you have two varieties of military commissions. And for the old one, the one that's still embedded in the Uniform Code of Military Justice, the law as to Miranda will apply, including the public safety exception, it's a non-problem. The law as to confrontation of witnesses will apply. The right to counsel will apply. So how can it be that only these kinds of military commissions, we have to tinker with basic legal propositions, but in these other military commissions, which Congress has retained on the books, we don't have to worry about them? I don't get it.
And we're going to open the floor now to questions, and I just want to make the observation that it seems as if we have two very different perspectives here about legitimacy and what set of procedures would constitute or would best foster the impression worldwide that our Article 3 trials are legitimate. And I just find that very interesting. That seems to be the central inflection point here. Please raise your hand. There are two volunteers with microphones. Keep your questions. Please don't make statements, because I will interrupt you and ask you to ask the question. So why don't we, that gentleman in the back raising his hand right there.
Mr. Francisco, you placed a lot of emphasis on individuals that we pick up on the battlefield, and I was wondering if it was important to you that we actually pick them up, because there is evidence that a significant number of detainees, have been picked up by other rival militias, and that there are political disputes here. And if that is important to you, my second sort of question is, where we have people that have very little evidence, the distinction between commissions and courts seems really unimportant if we don't have a place to put these people anyway and we continue to detain them regardless of the outcome. So I'm wondering if, talking about this distinction is sort of getting ahead of ourselves if we don't know what we're going to do with these individuals.
Sure. Whether we pick them up or whether our allies pick them up, to me, is not really a distinction that bears on the importance of having a system of military commissions, other than, in my view, to highlight why, in many instances, a system of civilian justice is not going to be able to adequately handle somebody who was picked up on the battlefield by not even an American soldier, but by someone else, and where the evidence of any wrongdoing and the witnesses to any wrongdoing may no longer be in this country and may not be easily accessible to the U.S. criminal justice system, because those witnesses are abroad, and the evidence that we do have might fall into areas of inadmissible evidence. But to me, that is very relevant to deciding, is this person actually an enemy combatant that we can hold? That is a separate question from whether you ought to criminally try them, whether you can hold them as an enemy combatant. And a lot of that evidence will often be very relevant to whether we can hold them in the first place. Your second question, where we ought to put them, I think there are lots of options that are out there in the world and on the table. I kind of go for the Bagram example myself for many of the reasons that Stephen doesn't like it.
It's the moderator's privilege to have the former Solicitor General, Mr. Dellinger, ask a question as well.
My question is whether there's any reason to close Guantanamo, which, while once a symbol of a law-free zone, is no longer, as a result of the Supreme Court's rulings that the Constitution actually applies as if it were any other part of America. Why close Guantanamo and send, where we spent hundreds of millions of dollars, and move people to some godforsaken rehab prison in Illinois, especially when there has been discussion in the press that the president is willing to let Congress have a say in where individuals are put on trial and whether they have a right to be tried in an open U.S. federal court in exchange for support for closing Guantanamo, which seems at this point to be utterly symbolic, beside the point, and not necessarily in the interest of any of the people who are detained. So that's the question. Why close Guantanamo?
Is it a great white whale at this point? Is it essentially the great white whale at this point?
Yeah, good question, Walter. I don't know if any of you noticed a little letter that appeared in the Washington Post the other day from a man named Charles Krulak. Does the name Krulak ring any bells? Any former Marines here in the office? General Krulak was the commandant of the Marine Corps some years ago, and this is what he wrote. The real absurdity of the Guantanamo boondoggle is that we never needed to spend a dime to create it. Now, that doesn't meet the sunk costs issue, so fair enough. We've already spent that dime. He also wrote, the greatest cost of Guantanamo has been to American global leadership and credibility as a nation that respects the rule of law. So one could make every possible practical argument. Let's not throw more money into, let's not throw additional money upgrading Thompson, for example. Let's just, the costs are sunk, that's it. I don't think that's a complete answer. I think there are issues, the symbolism issue I think is potent, but there are issues of additional expense going forward. It's wildly inconvenient to get to. That is not only an impediment to the administration of justice, but it also is an impediment to the ability of people like victims and victims' family members to show up and see the proceedings. I mean, there is something about having justice administered more or less locally. And I think that the longer we keep Guantanamo, including the, never mind the symbolic aspect, which is dispositive from my perspective.
Gene, let me just make it clear. Having the trials somewhere else, New York City, Illinois, wherever, is a different issue from where you house the detainees. Why make a political trade-off to move the detainees from a place where they now have full rights in exchange for giving up the right to have them tried in federal courts? I'm talking about just where they're detained. You might well want to have the trials take place in federal courts in Manhattan or Illinois.
I misunderstood your comment then, Walter.
We're talking about the issue is whether to close Guantanamo and move the detainees somewhere else, when that used to matter because it used to be that Guantanamo was alleged to be a Constitution-free zone. Where you place someone on for the purposes of having the actual trial is a different question.
Minister, there's no present movement to take the military commission trials out of Guantanamo. I mean, that's where we are right now. Congress has created this logjam, and the administration, by being indecisive at bad times, time and time again, has permitted Congress to create this logjam. So, I understand there's a difference between the two, but in neither event, do you really want to have Guantanamo to house 48 people? Are we going to spend that kind of money for 48 people?
I think it's a great question, and I think the great irony over the last 9 years of debate about Guantanamo is Gina's right to focus on we're now down to 48 people, 48 of the 800 who were originally there, 48 of the tens of thousands that the United States has detained since the attacks of 9/11, if you count Guantanamo, Afghanistan, Iraq, and the secret detention facilities, 48 guys. Many of whom, of that last set of 48, it's even smaller because some of them, had we had the criminal offenses on the books in 2001 we have now, we could have just prosecuted. Some of them either we tortured or we just simply didn't have a clue or a thought that we would ever do anything with them other than hold them indefinitely. Had we thought about it initially, so it's, we could have now prosecuted them. So if you exclude that category, we're now less than 48. The great irony of this is, I agree with you. As a matter of the particular human rights of these particular individuals, 48 guys, the conditions at Guantanamo, by all accounts I have seen, are better than the conditions that they would walk into, by accounts I have read, at Thompson in Illinois. The most compelling argument that remains for closing Guantanamo is an argument that favors national security over the human rights of those individuals. Why? Because of the argument that Obama and candidate McCain and General Petraeus and everybody else who seriously thinks and works on issues of national security say, go to your local, what they call radical Islamist terrorist website. What's the picture you confront on the front page of the landing page? It's a picture of Guantanamo on the one hand and Abu Ghraib on the other. And you say, isn't this just symbolism? And I say, yes, but it is a symbolism that has a staggering practical effect on both our ability to get information out of people we capture and the staggering recruiting capacity of organizations that want to do us harm in the future.
It's interesting. What was the name of that prison in Berlin that we kept?
Spandau.
Rudolf Hess. Spandau prison was down to, after they let Speer go, it was down to Rudolf Hess. At least Hess had a trial. The 48 people are not even going to have a trial. It really doesn't make sense.
Let me just add one small, because I think the politics of it are a little more complicated, Walter. I think we would all agree that you don't solve the problem of Guantanamo by moving Guantanamo. And one reality about Guantanamo is precisely because it has become such a symbol. It creates its own political pressure to resolve what are still very important unresolved questions, namely, most importantly, I think, what are we going to do with these 48? And one of my worries, although we have certainly urged the closure of Guantanamo for many, many years, is if we take everybody and move them to Thompson or wherever, there will be a sense we have solved the problem because Guantanamo is over. And we will be avoiding an issue that I think we have to confront as long as they're sitting in Guantanamo. And so I think it's a little complex.
And I have to say, I actually do disagree with the proposition that we don't solve Guantanamo by moving it. And I think it's a little bit of a pushback to Walter's premise. And Mark, you failed to mention Walter's most important position in the government, which was not as Solicitor General, but as the head of the Office of Legal Counsel. And it's in that position where I think Walter probably made his most important and most significant decisions, and where he also, I think, sat in the office where the Nazi saboteurs were tried during World War II and then rapidly executed after their conviction. Is that right? Is that the office you were in, Walter? But to push back on the premise, Guantanamo there are some rights that extend to Guantanamo. Is it established as someplace where the Constitution fully applies? I don't think we're there yet. Maybe that's where the court would ultimately head. I don't think we're there yet. By moving them, from my perspective, you can either exacerbate the problem of according full rights to those at Guantanamo, or you can eliminate the problem. By moving them into the United States, and I think this is the genesis for a lot of the pushback of moving them to Illinois, I think you move them from a situation where the Constitution's application is somewhat uncertain to where the Constitution's application is maybe not certain, but far more certain than it was at Guantanamo. Whereas if you move them away from Guantanamo to someplace like Bagram, then you move them to a place where it's less certain that the Constitution applies. That, I think, is the real politics of this from a real policy perspective, even aside from ideological politics, why I think that policy people have such a strong disagreement on that, because the move does change the legal status of the folks being held at Guantanamo relative to what it is at Guantanamo.
It's very interesting to note that it would seem to me that the view inside the Justice Department among high-ranking officials now tends towards Walter's view about the priority of closing Guantanamo in these debates, which may or may not be an interesting factoid, but I think at this point they're very much. Their belief essentially is that eventually, since the Supreme Court in Boumediene granted habeas corpus, eventually the Fifth, Sixth Amendment, and various other rights to trial will be applied to the detainees there anyway. All right, let's continue with questions. This gentleman right here in the front. I should have asked if there are any more solicitors general or heads of OLC.
I don't qualify. We've talked sort of glancingly about the 48. The administration offers 4 reasons for not putting these people on trial: that they're operationally high up in Al-Qaeda, that they've had training in Al-Qaeda or Taliban or related camps, that they've said, I'm going to go out and reoffend, or that they have connections, including family connections, to terrorists. I'd be interested in the panel's comments on the first question as to whether, granted that there's habeas, under international law, you can hold people without trial, regardless of whether it would be before a military commission or in a civilian court. And secondly, whether any of these criteria strike you as plausible.
That's a great question. So let me answer it directly and then give you what I think was...
And answer it indirectly.
And then answer it indirectly, that's right, having been given the platform. So the short answer to your question is there authority under international law, and I would add the statutory authorization for the use of military force, to detain people without trial in an armed conflict? The answer to that question is yes. That has been lawful. The question, the gigantic debate for the last near decade, is what counts as an armed conflict under international law and the authorization for use of military force. So everybody thinks Iraq, yes. Afghanistan, yes, although the Bush administration didn't initially take that position. And secondly, who is detainable if you accept the armed conflict definition? The 4 sort of descriptions or criteria that came out of this report, and this is actually a report that I've been meaning to blog about. I think it got way too little attention when it came out, and I hope I still will get to it, was a report, really the first and only official statement catalog of who is at Guantanamo, who remains, and what is it that worries us about them. Which came out just a couple of weeks ago. It is the report, or at least the summary of the report, of the Guantanamo Task Force that was formed when Obama took office and formed by executive order. So really important report. I'd commend to everybody's attention. Any of those descriptors that you just gave could, either in combination or by itself, describe somebody who might fall into the category of somebody who could be detained under existing authorities. So I would say it depends what else is going on with these people, and for some of them, just the criterion alone. The more, I think, useful, telling, interesting, and particularly for our purposes, findings or descriptor in the report was, so why aren't these people, who may be detainable or may not be detainable under international law, why aren't we trying them? Why aren't we prosecuting them? Because even the president, and particularly the president, took the position and has long taken the position that if we can prosecute them in federal court, we should. Now, that position may be changing, but that was at least the initially stated position. And they list 3 reasons. One is because they were captured and no evidence was collected, and nothing that could be used as evidence. So in other words, very much consistent with the practice in 2002, we were just detaining people all over the world with no end game in mind. Were we going to detain them under the laws of war? Were we going to prosecute them ever criminally? And there was just no long-term or even moderately short-term view. So we didn't even try to either Mirandize them or anything else. There was just no thinking given to that question. And that, I would say, describes, or at least according to this report, the vast majority of people who remain. The second is what they call, and I think is fair to call, jurisdictional limits. So, for example, the material support statute, the federal criminal material support statute that's on the books now, didn't have extraterritorial reach in 2001. So when we picked some of these people up in Afghanistan in 2001, who we could now prosecute because the statute has been amended and was amended not long after 9/11, we could criminally prosecute them now. We couldn't criminally prosecute them based on conduct at the time they were picked up. Some of those people may have actually committed war crimes. Some of them may fall into the kind of jurisdictional gap that one might imagine would justify a military commission or court-martial if the other criteria were met. And a third category is people who we either, and the report says this is a limited category and it's hard to tell, who we either tortured or made promises to foreign intelligence services that we would never use the information they gave us in any proceeding of any kind. So that by decisions made by the last administration, they are no longer prosecutable for reasons hopefully we wouldn't make again. Those, I think, are the sort of more important set of reasons to look at the report and probably push the administration on further.
Let me just add two other quick points. One is that I think that as we think about this category of people that the government wants to hold without charges or trial, we ought to keep the habeas cases that are now going on in the D.C. courts in the back of our mind, because we've been told for many years as well that all those people who are being held in Guantanamo were the worst of the worst or some variation of it. And as the government's evidence has been tested in habeas corpus proceedings, in 75% of the habeas proceedings that have gone to decision, federal judges have determined that the government has been unable to carry its burden in what is a diminished burden and a proceeding in which the government has almost all the control of the evidence. And so the factual, predicate, which is because the government says these people are bad even though we can't prove it, I think may be true in some cases, but is one that we ought to treat with a certain amount of skepticism. We ought not to just accept it without any sort of examination. The second thing is, we haven't talked at all today about how other countries deal with terrorism. And Noel said earlier, and I think many of us would agree, that the American justice system is a paradigm and a model for much of the rest of the world. We are the only, for all intents and purposes, Western democracy that has decided to treat terrorism on its own soil as a military problem as opposed to a criminal problem. The bombers in the London subway were tried and prosecuted. The bombers of the Madrid subway system were tried and prosecuted. And I think it's a fair question to ask why, if the rest of the world finds their criminal process sufficient to address what is in many ways a much more serious and long-term and more endemic process of terrorism, we start from the proposition that we have to create an entirely new system. Why is that?
I think there are a lot of different answers to that question. One would be that we strike a different balance on national security versus criminal justice. The other might be that our system of criminal justice actually is significantly more protective than most other countries, and so there's a bigger gap between what the criminal justice system provides and what you think a system governing terrorist detainees ought to provide. If you provide fewer protections on the criminal justice side to the defendants, then it is closer to what you would accord on the other side of the balance. I don't know that that's true. I'm just surmising. To me, probably the more fundamental answer is that we strike a different balance in this country on national security versus domestic criminal justice.
Final question. The young lady in the back there.
I have a follow-up to that question, and then a sort of a follow-up to the follow-up. So the follow-up to the question is, I'd like to know more about what the panelists think we should do and can do about people who we do have evidence have every intention of committing heinous terrorist acts, but we can't convict of having done something in the past. And the second question is sort of the flip side, and I'd actually be very interested in Mr. Francisco's remarks, but everybody's. Why is it that there are so many people who have been held at Guantanamo who the United States has conceded, in fact, have not done and don't intend to do anything bad, but have continued to be there for years and years and years? Why haven't they been released? I understand the political problem of releasing people into the United States, but from talking to lawyers who've represented some of these people, it appears that they are trapped in a Kafkaesque nightmare. So that's my question.
All right, we go from left to right, and everyone can
Let me take the second question, because I think that's one that you put more to me. I don't purport to know the whole range of the folks at Gitmo. I think the class that most quintessentially fits into the problem you described are the Uyghurs, where the Uyghurs were found in Afghanistan. I think the understanding is that they were there to train with the Taliban or with Al-Qaeda, but not to fight against the United States, rather to fight against the Chinese. And as a result, they do not harbor and did not harbor hostile intentions against the United States, and so are not a group of people that we ought to be holding as enemy combatants. I think the reason they're caught in this Kafkaesque world is because we don't think we should hold them, but we also don't think we want to release them into our country, and nobody else wants them either. So it's really somewhat of a dilemma, and I don't know what the right answer to that dilemma is, but I think that explains why they're caught in this very strange space.
Well, they're both good questions. I personally don't see why the Uyghurs weren't just given special parole, which I think the Attorney General can give, into the United States. I mean, there is an escape valve in the immigration statute, which could have been used, and I think it should have been used. For the rest, Congress has made life difficult for the administration and other countries. And here, interestingly, the answer to that question ties in with all of the other things that we've been discussing here, because one of the problems that we've encountered is the reluctance of other countries to take these people back, right? That's why at least some of the ones who have prevailed in habeas cases haven't left. Why might that be? Well, there are some countries that we don't want them to go to, because like I guess Yemen is in that category. But there are other countries that won't play ball with us. And why won't they play ball? For all of the reasons that we discussed before about the symbolic aspects and the fact that what we've done has been so offensive to values of other countries. Now, your other question was what? What to do about the people? Yeah, they have to be released. And will that create a risk of violence down the road? Yes. Will some people, and I'm not being cavalier about this, you asked the question, will some people who are innocent become innocent victims of violence at the hands of such people? It's entirely possible. Will some of those people who, let's say, do return to the battle or enter the battle for the first time, assuming they weren't previously wildly radicalized and engaged in terrorism, will some of them lose their lives in the process? Yes. So both they and people who are innocent bystanders are going to pay a penalty. Is that a penalty that it's a terrible, benefit cost analysis? But what value do you place on the adherence of this country to the rule of law?
Do you want to briefly analogize the release of repeated convicted sex offenders who are monitored after their release?
But they've been convicted.
Right. But I'm saying
And
the
they can be
release at least
monitored.
the release is subject to conditions.
Two really good questions. First, again, on your second question, why are some people there who the last administration, this administration, and now in many cases federal courts have said there's no reason to have them there? The quintessential case, the Uyghurs, the U.S. has treaty obligations that we, for whatever reason, take extremely seriously on this question, not to send people back to places where they're likely to face torture or persecution. The Uyghurs are a quintessential case of this. A Muslim minority in China, if we send them back to China, they'll be tortured and probably killed. So we can't send them back there, and we shouldn't send them back there. So how do you find somebody else to take them? In the Bush administration, could somebody else please take the people we have now spent the last 8 years calling the worst of the worst on the planet, and otherwise offending? The answer was no. The Obama administration, in my view, and I criticize them for other reasons, but on this, they've found a staggering amount of success in finding other places to actually take not only the Uyghurs, but other places. Why not just, as Jean suggested, welcome them into the United States? On the Uyghurs, for example, but there are other examples as well, the answer from Congress was, if you do this, we will cut off all authority to transfer anybody from Guantanamo into the United States for any reason, including criminal prosecution. And indeed, you have legislation pending right now introduced by Joe Lieberman and others saying we should never, thou shalt never, prosecute any terrorist suspect in federal criminal court ever, whether at Guantanamo or anywhere else, a position far, far, far to the right of any position taken during the George W. Bush administration. So I think it's important not to undersell the constraints that Congress appears poised to impose on the administration.
Refuses to fight against that, even if it's an executive, a matter of executive power. The administration just, for whatever reason, will not take the position that they can determine how they transfer prisoners.
Well, so that's a very important additional question too, but there are enormously complex politics going on there.
So another example of President Bush's moderation.
Yeah, exactly, absolutely. So what do we do with people who we really think are dangerous? And here I would distinguish between problems of the form of the evidence, that is, is it a problem of classified information? Is it a problem of the sources? But the information, if admissible in court, would be compelling enough to convict, say. Or the problem is sufficiency of the evidence. What is it, in fact, that we know about this person? For questions of form of the evidence, those can be complicated and so forth, but the kind of person you describe, the person who is planning to attack, is engaged in any sort of plans to attack the United States, engaged in terrorist activity, that person is sort of quintessentially prosecutable. That is the kind of person who, through a host of inchoate offenses that existed before and after 9/11, could be prosecuted, and the question is what forum and what are the exceptions, and does CIPA, the existing classified information protection rules, are those adequate, or do we need to sort of look at those? Those are totally legitimate questions, but that category of person, if not otherwise squarely within the existing authority under international law for detention in an armed conflict, is completely prosecutable. To me, the much harder set of questions is sufficiency of the evidence. What, in fact, do we know about this person? That they once stayed at a guest house frequented by members of Al-Qaeda? To me, that's just not remotely sufficient either under international law or sufficient to think this person is dangerous and poses a threat to the United States. Worse, there is a lot of evidence to think that if we go around detaining everybody we think has ever stayed at an Al-Qaeda guest house or otherwise meets this sort of threshold level of this makes us nervous, but do we know this person is dangerous? No. If we detain all of those people who are undoubtedly low-level, at best, operatives in some sort of very diffuse terrorist sort of structure, there will be 10 more who take their place, driven by the argument that, look, the United States will detain anyone.
Yeah, Noel was talking earlier, we were all talking earlier about spillover effect, and when we used that term earlier, we were talking about whether trying some of these alleged terrorists in criminal courts would cause the courts to water down Miranda protections or confrontation clause protections. There's another very important spillover effect that I think we have to ponder, and that is that some of these 48, as Deborah was outlining earlier, are people who we can't prosecute because the evidence is tainted, because it was obtained through torture, or we can't prosecute because even if the material support law in 2001 or 2002 had applied extraterritorially, the statute of limitations has now run. And so we've screwed up. We screwed up because we've locked them up for 9 years without prosecuting them, and now the statute is run. We've screwed up because we tortured them, and now we can't prosecute them. To say those mistakes of the past now entitle us to hold somebody indefinitely without charges or trial because if only we hadn't screwed up, we're sure we could have proved that they were dangerous people, is, I think, a road that we can't go down. That sort of preventive detention regime would be an enormous transformation in the way our legal system has traditionally operated. And once you cross that divide, once you say, there are dangerous people out there, we can't quite prove it, and or maybe we could have proved it if we charged them in time, but we didn't, but we're going to lock them up anyway. There are a lot of dangerous people out there who aren't only terrorists. And you're not going to be able to cabin that principle once it becomes ingrained in the American judicial system. So at the end of the day, the practical problems are enormous. But I wind up where Gene winds up on that question.
And without any elaboration, I would just say, Stephen, that's I think, largely my point.
Thank you very much to the panelists, to the audience, to Sidley Austin, our sponsor. Please go enjoy lunch, and Cory Booker, who is the luncheon speaker. Good day.